welcome to Lawline with your host, David Schnurman, an accomplished entrepreneur, attorney, and legal educator. Each week, Lawline will bring you the most knowledgeable experts in the field of law, business, and education. And now we introduce our guest and our host, David Schnurman.
Hello, I'm David Schnurman, and welcome to Lawline. In this day and age, you have instant access to all the content you wish at your fingertips, thanks to the internet. However, recently, the U.S. government has taken steps to regulate the internet through legislation. At what point does this control turn into censorship? How successful can this regulation truly be? To sort this out, attorney Markham Erickson, who has served as lead counsel to Google, eBay, Amazon.com, and Skype for the Net Coalition, and Hillel Parness, who represents and advises clients in copyright, trademark, and internet legislation. Welcome, Markham. Welcome, Hillel. Markham, let's start with an overview picture of what's going on right now, where we come, and why is internet regulation so important?
There's always been classically a tension between the interests of rights holders in the copyright space and the interests of those that provide technology and those that provide new means for people to distribute content. So in a very real way, this is a continuation of a very long life cycle. The reason we're so concerned about regulating the internet here in this space, my clients, is because the reason U.S. internet companies dominate the world and that there's really no European counter to Facebook or Google or Yahoo is because we have the best legal system, the most healthy legal system for the development of technology in the United States. Some of that's by accident. We have a First Amendment. We have a Constitution that is very permissive for the creation and distribution of content. But we've also drafted laws that intentionally allow the internet to flourish. And those laws basically stand for the policy proposition that intermediaries, those that are simply facilitating communication of others, like a Google or an Amazon or an eBay or Facebook, that are platforms for third-party content, are not held liable for the publication of that content by third parties, and they're not required to actively police their networks or monitor their user behavior to seek out illegal activity, as they might be under traditional theories of liability under existing laws, including copyright.
But let's just break it down for the consumer who's hearing you talk.
Yeah.
So how does this affect me? Hillel, how does it affect somebody right now who they hear about, they hear words like SOPA and PIPA, and they hear about coalitions, they hear about net neutrality, which we'll get into. What does this really mean to them, and should they be concerned?
Well, as far as PIPA and SOPA and open and those laws that they're talking about, I don't see a lot of impact, although Markham might disagree, on the average consumer. In fact, I don't see a lot of impact on domestic U.S. players, because those laws were all focused on foreign websites. They come out of a frustration in the copyright community and the content owners community that while the U.S. laws that apply to U.S. companies might be adequate, we have a real problem with foreign laws, foreign entities that are not respecting U.S. laws. So, for example, if there's a foreign website that is dedicated to the theft of U.S. property, to use the term that's in SOPA, we can bring a lawsuit in the U.S. and get an order from a judge, but if that website's not going to respect the order of the U.S. judge in the way that a U.S. company might respect it, then the owners of the content, the ones that are driving a lot of this development of the internet, aren't going to get any real satisfaction.
I just want to break this down. Isn't this whole thing about, at the end of the day, we're talking about intellectual property and corporations protecting their intellectual property?
Well, that's right, but balanced against that, and our Constitution requires this, we have to consider the interests of users to exercise their First Amendment rights, and the interests of companies that are simply distributing that content and actually aren't producing the content themselves. Current law strikes an appropriate balance for that balance between creativity and protecting copyright owners and technology.
Can you give me a real example of what you're saying? You mentioned Google or Yahoo. So if an individual user, and I only can think of the mega uploads case, and I don't know if this applies, the individual user uploads something that's illegal or they don't own the copyright to it. Is Mega Uploads or Google or Yahoo at fault?
So under current law, if there is a YouTube or some sort of social media site that allows other people to put up content, the platform, the Facebook or the YouTube, is not liable for the uploading of that content if the content is being illegally uploaded. What the law says is the rights holder is in the best position to know if that content is being illegally distributed, and if they contact YouTube or Facebook and tell them that this content is being distributed on their platform illegally, then those companies are required to expeditiously remove the content. They notify the person who put up the content to say if you disagree, if the content is your content or you have a license or this is uploaded pursuant to fair use principles, we'll put it back up, and then it lets the rights holder and the person who put up the content fight it out to see who's on the right side. But it keeps my clients, the internet companies, out of the position of having to make complicated legal decisions and does not require them to actively monitor and police their networks looking for that activity. That's the reason the internet's been so successful, is because those companies don't have to create elaborate systems to try to pre-screen content that's being put up on the internet.
And I largely agree with what Markham is saying, although I think a lot of what he's saying is not in the text of the statute, but what his clients believe the statute is about. And he's talking not here about SOPA and PIPA, but about the DMCA, the Digital Millennium Copyright Act, passed in 1998. Not any of the current laws we're debating now, but a law that was passed some time ago.
Still valid.
And still exists, absolutely exists, and isn't affected by SOPA or PIPA. But just to put a footnote onto what he's saying, in order for a company like YouTube to take advantage of what we call the safe harbor under the DMCA, which is what Markham is talking about, they need to have certain things in place, including a repeat infringer policy,
sure,
including the facilities to respond to notices and take them down, but most importantly, perhaps, is the concept of red flags, which is getting a lot of attention in the courts now. And that's always been part of the balance. Since it was passed in 1998, the idea of a red flag was always there, which says that if there is something that is so obvious to the site that is dealing with infringing activity, under those circumstances where a red flag exists, it actually does have to take an affirmative step to do something about it. It cannot wait for the notice. It has to do something. And the debate right now in the courts, specifically in a case involving YouTube in New York and a case involving a company called VO in California, is what does it take to have a red flag? Both sides agree that red flags are part of the balance and part of the system, but no court yet has actually found something that it believes is a red flag. And that's caused a lot of concern on behalf of the content owners.
Is the red flags what happened in the Mega Uploads case? Because it seems to me from the outset, I don't know what due process was here. They shut down a site, put somebody in jail because of intellectual property issues, the wrong copyrighted information. What do you know about that case, and how does that fit into this?
I've only read the Department of Justice pleadings, and so and I haven't been on Mega Upload's site. I know very little about their process, what they do as a business. I know they're a cyber locker for content. I think, though, we have to be very careful here, because traditionally we've litigated these issues in the civil context through rights holders suing technology companies. When you bring the resources of the federal government into bear and you begin to remove content, to seize content, including content that isn't Mega Uploads. It's people that have put their content to store on Mega Upload servers. There's a very careful balance that the federal government needs to engage in to make sure that they are following all of the due process requirements that they are supposed to under law. And we've seen some high-profile examples where they haven't done that,
sure,
where they've taken down sites, they've seized the sites, and then a year later they return them to the owner of the site without ever filing a case against the site.
Hillel, does this scare you? I mean, you think about what's going on there, as well as some of the things that they're trying to put through in terms of regulations. It seems like with the internet, the government can really shut down the site with literally a click of a button and shut off the DNS, and it's pretty scary.
Well, let me get to that. Just a little bit of background on Mega Upload first. Mega Upload was not brought under the DMCA and has nothing to do with SOPA, except by way of explanation. Mega Upload is a criminal case. There have been criminal provisions of the Copyright Act for a long time. These are not new provisions, and they didn't come into existence because of SOPA or anything else, where in parallel to the civil copyright laws, there are criminal copyright laws, which says if the government wants to, the government can decide to bring a criminal action against a site or against an entity or a person, an individual or a company that's engaged in criminal copyright activity.
Is that what happened with the iTunes, or just with Napster and people who downloaded stuff like that?
No, Napster was a civil case. The government did not get involved in that.
But I think that's a good point in that there is a lot of concern from our community. Copyright issues are not black and white issues traditionally. They are litigated issues. It's judge-made law. The statute doesn't spell out what the permissions are for people to host third-party content. And so normally how copyright law develops is through civil litigation and the development of case law that gives everybody sort of a sense of what the boundaries are in developing technologies. So when Sony developed the Betamax, they had or the VCR, they had a technology that the Hollywood studios sued and said, you know, Sony is aware that people are using this device
case, right?
for, it's the Sony Betamax case, that they know is being used for illegal activity. They are selling a device that they know users are using for illegal activity, and so they should be liable as a secondary infringer. And the Supreme Court said, no, as long as the device is capable of substantial non-infringing uses, we're not going to hold the technology liable. That was not necessarily obvious at the beginning of the case that that's where that would head. So I think when you're taking complicated issues of copyright law that reasonable people can differ, and the government decides to take a criminal case against those technologies, it's a little disconcerting when reasonable people can differ whether the technology should indeed be illegal.
And you have to wonder, especially large corporations have an effect on what criminal proceedings are being done, because certainly mega uploads, this is being done all over the place. It's not just mega uploads. There's lots of smaller sites that aren't as flashy and don't have as much issues there. So why them? Why now? And that's where, you know, there becomes this concern that the individuals are, you know, you have no control of what's going on in the government or corporations.
But David, can I respond to something else that Markham has said, right? I think Markham was expressing concern on behalf of the users that you know, there are users of Mega Upload. Many of them might be uploading things they shouldn't be uploading,
right?
But there might be a lot of them that are uploading things they're allowed to upload, things they wrote themselves or public domain things. And Markham expressed concern that those people might get caught up in this criminal case that's been brought. And I think the same could happen in a civil case. I don't think it's a criminal civil thing. It reminds me of the following example. This actually happened to my brother. He called me up one day. He said he can't get his clothing out of the dry cleaner because the dry cleaner has been arrested. The dry cleaner was arrested for money laundering, and they shut down the dry cleaner, and all the customers' clothes were stuck inside the dry cleaner. Now, I think that might be upsetting to the customers, but that will happen from time to time if the dry cleaner or the site is involved in criminal activity. There are going to be side effects, but this is not a new concept.
The difference there is certainly you're not uploading. People, unfortunately, are for the the internet's so easy to upload things that you shouldn't. Your tax returns or whatever you upload things in there because you think it's safe.
Well, the other point is the reason traditional landlord liability doesn't apply to the internet copyright space is there's so many billions of transactions every minute on these platforms that they have no way to know whether someone is engaging in illegal activity or not as those bits are being processed on their platform. So we really do rely on Hillel's clients to say to us, hey, there's something that's being posted illegally, would you take it down? I think his clients would say that my clients take it down very quickly, are very responsive in that space. The real question that we are going to have to confront going forward is whether that's enough to protect the content owners, whether the current balance of saying we don't have to, technology companies don't have to police the internet, they don't have to look for illegal things, is the appropriate balance. I think that there are many in the copyright side that say it's too onerous for us to have to let them know when there's all this content that's being distributed illegally. On our side, we're very concerned that once you start going down the road of holding our companies liable for posted content or saying that we have to actively police user activity, it's impossible to do in any effective way, and it really changes the way the internet works. And that's why we had all of this user backlash against SOPA and PIPA, because where I do disagree with Hillel is that even though the bills were ostensibly targeted at foreign sites, the remedies were all directed at US companies, at intermediaries, at search engines and payment processors to get them to do work on behalf of the entity that was complaining that there was an illegal activity taken. And those liabilities and those responsibilities are really a regulation that goes way beyond what current law is today, and that created the concerns for my clients.
If I remember correctly, the day SOPA was in the Senate or the Congress, I remember Wikipedia did blacked out their site, Craigslist blacked out their site, some other major sites, maybe Google put something up on there. So it's the voices that are coming out there and saying stop, and that's what brought it to the attention to millions of people. And by doing little things like that. I know you were about to say something.
SOPA is a complicated statute. It's some 72 pages, and what I've found in talking to a lot of people is that very few people have made it all the way through the 72 pages. I know you have.
Who writes these? Lobbyists? Generally, in legislation, is it because it's usually written in favor of somebody?
Yeah.
So is it written in favor of corporations?
Well, you know, it's written by the lawyers that work for the committee, but they do reach out to stakeholders on both sides to get expert opinions on how to draft these, and you know, there's always debate on who they're listening to more.
Hillel, where do you think it weighs more towards? Is it more favorable to the copyright holders, the corporations, or those who upload protecting people upload their information?
Well, no, I think certainly it is aimed at enhancing the protections to the copyright owners. I would have to think about it. I don't think that you can point to provisions that are there to enhance the protections of Google and YouTube, for example. But again, a point of just clarification, which is that it does talk about these intermediary services that once you get a court to order and find that a site is a problematic site, a site dedicated to the theft of intellectual property, you can take that order with the court's permission. Again, that would be on the criminal side, but for example, if there's a foreign site, and SOPA is a civil statute, but if there's a foreign site and there's a problem with it, you can go at it two ways. One way is to have the government go at it, and there's one provision of SOPA that gives the Attorney General certain powers, and there's another section of SOPA that gives civil litigants those powers. In both situations, they have to start a lawsuit. They have to go to a federal judge with notice to the site and convince the federal judge that the site is problematic under the standards that are set down there. And in both situations, once, if and when the judge issues the order saying the site is problematic, the site's violating the law, with further court permission, either the Attorney General or the private litigant can then take that order and serve it on one of these intermediaries.
Except that's not the entire story. So the problem we had was that there's all.
Yeah. We have to go to break, and we're going to pick up on the way back. In addition to the following up on this, I also want to talk about the word "the cloud" and talk about that as well as net neutrality. You've heard that term go backwards and forwards, and you know, as a person, as an individual, you want to know what side should I be on, and why is it so important. So we're going to go to break, and we'll get back to these important topics. I appreciate that. You're watching Law Line. Stay with us.
I'm lucky. I get to do something I love.
How many of you think homework is just as important as teamwork?
I help keep kids in school.
Good.
And that's the name of the game.
My name is LaDainian Thomason. I don't just wear the shirt, I live it.
Give, advocate, volunteer. Live united.
The smallest moments can have the biggest impact on a child's life. Take time to be a dad today.
It started with a little pain in my knee. Now my joints hurt so bad, I can hardly walk. What's happening to me?
For answers, ask your doctor the right question. Could I have lupus?
Hi, you're watching Lawline. I'm David Schnerman. The topic is Internet Regulation and the Future. Our guests are Markham Erickson, attorney who represents internet companies, and Hillel Parness, an intellectual property attorneys. Before the break, we were having a pretty heated discussion on SOPA and things that are going on with mega uploads and the rights of criminal versus civil things that the government can do. I want to talk about the cloud. I mean, that's a word that we hear a lot. And I think that's what this all comes into now. What does the cloud represent? One of the things that's going on the past 6 months is companies, iTunes, Amazon, I think everyone but Google actually, is having players, instead of just being on your computers, you actually can upload all your songs to the cloud. Now iTunes will actually go into your computer, copy everything and put it on there. Amazon was the first company to do this, and now a lot of the companies out there are saying, whoa, you can't make another copy of this. This is against the copyright laws, and there's no cases yet because it just happened. Amazon saying we're pretty sure we'll be fine. The copyright holders are saying this is as bad as you get from articles that I've seen. Hillel, what is your opinion on what's going on with
First of all, Google's also doing it.
Yeah.
Right?
Google, yeah, I'm sorry, Google
is
with
doing
the
it.
MP3, yeah, sure, of course.
So I think that there's no right or wrong yet on the question of cloud. I think, first of all, cloud is a marketing term. I don't think everyone should understand there are no clouds floating around, although Google would be the first to build one if they could. But cloud just refers to the fact, in general terms, that you're storing your content somewhere else.
Sure.
That rather than storing it locally, you're storing it somewhere else, perhaps on a server farm. In my general view, if you're moving something from local to a server farm somewhere, it shouldn't change the fact that somewhere the content is being hosted somewhere, physical, on the ground, and it shouldn't change the ultimate question of whose rights exist where and who might have exposure if there's copying.
Well, there's more copies now. Instead of it just being on your computer, there's a copy somewhere else, and maybe they have backups, and there's 10 different copies around.
Right. Well, then that goes to the rights. That goes to the rights, and that's why iTunes is doing certain things with its cloud, but Amazon and Google have not done all the same things, because what I've read is that the record labels, for example, are not giving the same rights yet to Amazon and Google that they've given to iTunes, and that's why I believe it's Amazon is only letting you do certain things, letting people upload their own material, and it's not necessarily giving you access to their own copies of things.
The cloud is going to be how we interact with our content going forward, the primary way we interact with content. It basically means that you can have a very thin device that doesn't have a lot of memory, but because of the ubiquity of broadband connections and wireless connections and Wi-Fi, you're going to be able to store your content somewhere else and then retrieve it when you want to retrieve it and interact with it when you want to interact with it. And there is a lot of case law in this space generally. It's essentially a space shifting mechanism that allows you to put content somewhere else and then view it later. The questions become, the most complicated questions become, how open can that cloud storage be? Can you share that piece of content with an unlimited number of people, a smaller subset, friends, family, or just simply your different devices, your home, office, automobile? And those issues are not as easy to resolve.
Sure.
And what role the technology company, the cloud company, plays in creating certain limitations on how that content is uploaded, distributed, or monitored. And all of those are difficult legal questions. And in essence, the easier it is to share a piece of content with a lot of people without a lot of hurdles, the more it starts to get to the ire of the copyright owners, and that's where you see litigation ensue. And in some cases, common sense is the way the courts rule. Sometimes it doesn't make a lot of sense, but I think the cloud is here to stay, and I think consumers are going to want to see these cloud services, and we're seeing very interesting uses for the cloud, and how this works going forward will be interesting. Mega Upload is essentially a cloud service. Right. Now they allow some things that the government is saying moves them over into a copyright infringer, having to do with, I believe, the fact that they pay people for how many times other people are accessing the content that they put up on the site, where they're actually moving into sort of an inducement kind of role. They're inducing people to engage in illegal activity. But those issues aren't necessarily black and white. I don't know enough about Mega Upload to know, and they have to be litigated.
It seems like, if you're working with Amazon Cloud, for example, you upload a song, assume there's 100,000 or a million other people with that song, it would make sense to me that Amazon would just have one copy of that song that kind of serves out to everyone instead of a million copies of it there. So it seems like there's something in that to the future where it's easier to regulate if there's less copies out there that can be distributed amongst.
Well, that's an interesting question. I mean, I think a lot of copyright owners would say no. There should be one separate copy for each user that uploads it, and having one copy that everyone gets to share, even if they all paid separately for the copy, might raise some issues having to do with the ease and accessibility of that the copy and whether that infringes rights. Again, they haven't been litigated. I think in many cases. There was a Cablevision case here in the Second Circuit where Cablevision, the cable company, was making a copy of a DVR copy, something you were watching over the air, and they were making a separate individual copy on a separate server for every one of their users, even if it was the same piece of content. And that was done partly or mainly to avoid concerns that there might be copyright infringement issues.
Cool. It seems like, tell me the major players here. There's the major corporations that own the copyright, and then the major service providers such as Google, Yahoo, MSN, eBay, who have the content. Is that?
Generally speaking, you have the ISPs.
Against each other?
No, it's not. It's not quite as simple as that. Yeah, generally in this space, you have the major ISPs.
How many fights are there? Is the question.
You have Verizon. You have the access providers: Verizon, Comcast, Cablevision, people that provide you access to the content. There's questions about their role in illegal activity. You have the intermediaries that are on the edge, like Amazon, Google, Facebook. You have the rights holders like the Hollywood studios and music publishers and studios, and then you have the user community, the people that are interacting with these technologies every day and the content every day, and those are and then you have consumer groups, but those are the big constituencies, and trying to balance the rights of all of those constituencies is not easy. DMCA, as part of that negotiation, took about 4 years to work out. SOPA was being moved very quickly through the legislative process, and I think some of the backlash you saw was because it wasn't really thought of as a totally open process and it was moving so quickly.
Well, we only have a minute left. Time goes by much faster than you anticipate. Based on, we talked about the players, and you say, I don't know which fight we're talking about, is where, let's end this where we started this off, and I'll give you the last word. Where do you see the next few years playing out?
Just seeing how little time we have left. I think this is all part of a continuum, and something that I've been noticing and I've been speaking about a lot lately is that you see, if you go back about 10 years and you look at the cases, every once in a while you find a judge struggling with the following idea. He realizes that there's a service in front of him that probably violates existing law, but it's also made very clear to him that if he rules against it, he is going to shut off an avenue of technological advancement, technological development. And sometimes the judges will shut it down. In the case of Napster, they said this is a bad actor. We're gonna shut it down. Sometimes they don't. Sometimes they say I'm not going to be responsible for shutting off this avenue. And it's an ongoing struggle, an ongoing fight. And I think the story's just beginning.
Well, thank you, Hillel. Thank you, Markham. I appreciate it. It's an interesting topic, and I'm looking forward to seeing how the next 6 months to a year play out. And we'll have you guys back on to discuss where we're at. And thank you once again for watching Lawline. We'll see you same time next week.
You've been watching Lawline with your host, David Schnurman. Mr. Schnurman will be back with you next week at the same time. If you have any questions about this week's program, please send an email to info@lawline.com.